Welcome back, everyone. 14 and a half after the hour. And today in Behind the Headlines, we're going to take another look at the Kettle Falls Five case. We've told you about this case before. A family of five, actually four family members and a family friend who were growing 74 marijuana plants. They were busted and taken to federal court where their lawful use of medical marijuana, although technically speaking it's not lawful in Washington state, they merely have an affirmative defense, but still they were well within the guidelines for medical marijuana in the state of Washington, a state which of course has just passed recreational marijuana legalization. But that doesn't matter because the federal prosecutors, the U.S. attorneys there in the Eastern District of Washington have decided to go forward in prosecuting this case, a case that could bring 10-year mandatory minimums for everyone involved on every count they're involved, effectively meaning a life sentence for the 74-year-old patriarch of the family who has been diagnosed with stage 4 pancreatic cancer. But according to a post in the Inlander.com, the prosecutors in the Kettle Falls Five case are worried that despite all their best efforts to try to lock up a family of medical marijuana users, those users may go free. The prosecution is worried that the jury is going to exercise jury nullification and vote to acquit the defendants in order to send a social message. This has concerned the prosecution so much that they filed a motion on February 10th, just a couple of days ago. They filed a motion that said, quote, "The United States believes this indicates the defendants are attempting to engage in jury nullification." This that they're referring to is an article on Forbes.com by our friend Jacob Sullum that quotes one of the defense attorneys from the family. And even though medical marijuana can't be mentioned in federal court, everybody will get busted. There'll be a mistrial if anybody mentions the word medical or marijuana or the fact that these people were sick or even how much federal time they face if they're convicted. None of that can be mentioned at trial. And that's what's got the prosecutors concerned, is they feel that the defense is trying to get this information through to the jury in sneaky ways. Again, reading from their motion, circumventing the court's previous order and attempting to provide the jury with evidence by planting the seed and hoping it will germinate in the jury deliberation room into a discussion of issues which the court has already ruled are not relevant to this case and should be not considered by the jury. The law in this area is straightforward. It is improper for a defendant to suggest in any way that the jury should acquit the defendant, even if it finds the United States has met its burden of proof. Of course, the burden of proof that they're talking about in this case is whether or not those folks broke federal law. And on that, it's a slam dunk, folks. They were caught with marijuana plants. Even one marijuana plant is a felony under federal law. And so these prosecutors think they got an easy case in front of them, but what they didn't count on is that the rest of the community and the mainstream media and the world at large would focus on this case as an extreme abuse of prosecutorial discretion. Already, the U.S. attorneys and prosecutors at the federal level have been told through the Cole memo and subsequent follow-ups that they are not to use their limited time and resources going after the patients who are lawfully using medical marijuana in the states that have authorized it. Furthermore, we had action by the U.S. Congress that was then signed into law that forbade the Department of Justice from spending any money from going after state legal medical marijuana providers or consumers. But of course, this case started before that became law. I suppose the prosecutors would argue that it was already in the pipeline and does not apply to spending any new money. But as far as I'm concerned, this is going completely against the intent of the government, the intent of the Department of Justice at the federal level. And this leads us to believe that these are rogue prosecutors, completely ignoring all the guidelines from the federal level and moving forward with a case that serves no benefit to the public, to the general welfare, to the safety of the people in the state of Washington. Indeed, we have people that are growing thousands of marijuana plants in the state of Washington, not just for medical purposes, but for recreational consumption. and these prosecutors don't seem that eager to go after them. Why pick on a family of 5, most of them in their 50s, 60s, one guy even in his 70s, a guy dying of pancreatic cancer, a family that had been following the law to the letter, to the best of their ability? Why go after them? What kind of message do you send here? It's not as if you're going to overturn medical marijuana or get people to reverse their feelings about it. All you're doing here is hastening the end of federal prohibition. And I believe we are going to get a jury nullification out of this case. The case has gotten too big. That name, Kettle Falls Five, is easily found on social media and throughout Google and Facebook. Let's send a message. Let's judge this law as improper.